We are back in Senate Judiciary, March 19th, still on H2, and we have Whale Chester from Columbia University to talk about this. Did I pronounce your name correctly?
You did. Thank you so much. Yes. Thank you for having me. I'm going to share my screen for show some PowerPoint slides along the way, if that's okay. Let's see. Can you see that okay?
Yes.
And can you hear me okay? Never know.
Yes.
Great. Yeah, so I'm so happy to be here today. I wish I could be there in person, but I'm traveling at the moment. I have been researching emerging adult justice since 2016, when we created the Emerging Adult Justice Project at the Harvard Kennedy School. And then I've continued since that project switched over to the Columbia University Justice Lab in 2017. I research emerging adult justice both nationally and internationally. And I've been actively researching and tracking developments in Vermont, especially since 2018, when 7 years ago when you enacted Act 201, the Raise the Age statute. I wanted I've shared these slides with the committee, and I think they've already been posted, just sort of who I am or what we do. I want to just emphasize that the goal of Raise the Age is public safety. And I think sometimes we talk about all sorts of things, and yes, there's all sorts of good outcomes, such as more positive youth outcomes. Young people do better, which is, of course, our next generation, super important. But it's also a very strategic, smart move for increasing public safety. And so why is that? What emerging adult justice does is try to bridge the gap between what research tells us works and is effective and is fair and developmentally appropriate to implementing policies and practices that are driven and informed by that research. There are basically 3 bodies of research that are particularly relevant to emerging adult justice, and that is neurobiology, developmental psychology, and sociology, in particular life course criminology. And I'm not going to go into a ton of detail here, but just to remind folks, if you've heard this before, is that it turns out that emerging adults, especially 18 and 19-year-olds, share the same characteristics as their younger peers, right? The hallmark of emerging adulthood is risk-taking, right? They are incredibly influenced by their peers. They are impulsive. They don't think things through. They think about the moment. They do not think about the future. And so a lot of the techniques that are used in our adult criminal justice system for deterrence is pretty ineffective for this age group, right? They're much more motivated by positive incentives, for example, than any negative consequences. And the justice system basically is all about negative consequences. And yet when we apply that to 18 and 19-year-olds, we're really not getting much bang for the buck, right? That's just not an effective approach. And so that's what this is about. One of the other key pieces of the research is, okay, what is effective? And it turns out that most young people will mature and age out of crime by their mid-20s. And they do that sort of desistance is encouraged when they reach key developmental milestones. What are those milestones? Those are things like meaningful employment, and education, safe and stable housing, meaningful relationships, when sometimes it's parenting. When young people have the opportunity to practice becoming an adult, right? They enter these adult roles. they mature and they desist from crime. And so one of the issues with the adult criminal justice system is that in our attempt to increase public safety, right, and to hold young people accountable, which of course we need to do, we are unintentionally often undercutting public safety. When young people are saddled with adult records, for example, they cannot achieve an education. They often cannot get housing. They often cannot get meaningful employment, right? Just the act of being convicted versus adjudicated will impact their ability to grow, mature, and desist from crime. And so that's what this is about, right? This, how are we best going to support them and guide them and drive them to right healthy adulthood? And how can we do that quickly and effectively so that we don't have future victims, right? We don't have this cycle. And when young people get that adult conviction, it's very hard for them to ever come out of the criminal justice system. And if you visit, facilities where you go to sort of the geriatric unit and you ask them, what happened, over and over again, you hear these stories coming in as a young person and not getting themselves out. They never establish themselves as healthy adults in the community, and therefore they can't kind of come out of that cycle. So emerging adult justice is a burgeoning field. It's all about creating fair, effective, and developmentally appropriate services, programs, and opportunities, right? It tends to be strength-based and growth-focused. What can young people bring to the table? How can we help them to move them along into healthy adulthood? And again, it's all about public safety. Um, uh, so Vermont. Vermont embarked on this, as you know, by enacting Raise the Age to the 20th birthday. And then Vermont engaged in, I think, incredibly thoughtful process to create an implementation plan. And I say that because I got a firsthand look at how that worked, and I actually got a chance to try to support that. But really, it was Vermont leading the way. And it was led by DCF that brought together all the stakeholders from all the different aspects of your justice system, everything from DOC to state's attorneys to the defender, right, to barge, to victim rights and victim groups, to community groups. It was really from an academic researcher's perspective that's worked in many states now across the country on Raise the Age, along with other emerging adult justice policy issues. It was wonderful to see this sort of robust approach. And it culminated in a report that was submitted to the legislature on November 2019. And that report had a number of super concrete recommendations, right? These are the things that Vermont can do to prepare for Raise the Age, because certainly, as you guys, I know, just was listening a bit to the prior testimony, right? You're switching over 18 and 19-year-olds who are now in the adult system. So they are being served by your justice system, but primarily by DOC. And you're switching that to most cases, not all cases, going to family court and DCF. And I say not all cases because serious cases are not going to be in this world of Raise the Age, right? This is going to be, your more typical adolescent type case is the cases that are going to be captured by Raise the Age. And those are the ones we want to capture, right? That's the goal here. And so what's happened, right, since those recommendations were made, and the first phase of Raise the Age has been implemented. And right, 18-year-olds started in on July 1st of 2020. So you have almost 5 years of experience of implementing Raise the Age. You've done half of it. And so what's going on? How's it worked? You may recognize some of these slides because these are slides that we presented last year. What you see is that the number of cases that are filed in family division as a delinquent, we're not mixing up transfer, youthful offenders. This is about delinquency because that's what Raise the Age is. How's that gone? Well, it's quite remarkable, right? You just added 18-year-olds in FY21. And I expected, researchers expected that there was going to be a bump up in cases. But really, no. And the fact is that actually Vermont's not alone in this. Was we study states that raise the age from 16 to 18 or 17 to 18, we do not see a spike in cases, or sometimes it's a tiny bump up, and then like in Massachusetts, my home state, we've gone way down in the number of cases of delinquency cases. It's really remarkable after we raised the age from the 17th birthday to the 18th birthday. And Vermont really raised the age from the 16th birthday to the 19th birthday because you did a lot of work pre raise the age, bringing more 16 and 17-year-olds, more adolescents, giving them the advantage of being with the family court with expertise on this issue. You also see, oh, it doesn't want to change. Hold up. You also see, did I have this? Sorry, I think I skipped one. Yeah, okay. So hard for me to see because I've got I've got you in the boxes on the thing. We have the number of youth on probation, right? And that's where the vast majority, that's the most common disposition in juvenile court, right? Most young people, at the end of the day, if merits are found, they are going to be placed on probation. There's community supervision, community support, and that's very, very important. And yet, when you look at the counts of probation for DCF of all youth now under the 19th birthday, if they had committed an offense, they've gone down. That's great news. And then you think about the deeper end of the system. What about those that actually involve custody, right? Where young people are actually at a DCF facility or a contracted facility. And there's two ways in which young people in juvenile court that can happen. It can happen sort of predisposition, sometimes pre-arraignment at the front end of the case. They're presumed innocent, of course, but for various reasons are being held. Well, you look at FY 2022, there are only 6 youth that fit that category of that deep end. And then you also think about it post-disposition custody. And then again, great news for Vermont, you really reduce your numbers, right? And that could be within state, out of state, whatever. Custody, you've seen a nice chart going the right way with some really significant, substantial declines. The question is, and you may want to ask is, why are you not showing me the more recent numbers? You know, you sort of stop at FY22. What about FY23 and beyond? That is a problem that Vermont's been plagued with for a long time. Just getting those charts, which are the most basic charts on caseloads, is difficult. There is no publicly available data. We have to look at different sources to pull it. And we're only using publicly available data, right? These are the things that are being reported by either the courts or DCF or Barge or the state's attorneys or whoever, right? That might be reporting. And so I do not have the most recent numbers. What they should be reporting to you and what you should be asking for are pretty basic. How many 18-year-olds that were charged with delinquency went into family court the first year that raise the age was implemented for that first phase 1? How many of those 18-year-olds, right, ended up with actually merits found, and how many of them were successfully diverted? One of the biggest advantages of having 18 and 19-year-olds in family court is you have a robust diversion system in family court. You can sift out the cases that can be appropriately and effectively handled outside of the regular court system, where you're saving the resources of the court system for those cases that absolutely need to be in court. right? And when we discovered when we were doing the legislative report for 2019 is that a significant number of 18 and 19-year-old in adult court now are ending up with a conviction with all the collateral consequences that goes along with it, and a fine only. Well, if you at the end of the day think a fine is the most appropriate disposition for this case, that screams diversion, diversion, diversion. They did not need to go through all that court process. Those resources are better spent on young people who need more attention and care and support and direction and more services. So when the state DCF submitted that report in 2019, there's a whole section on data collection and analysis, which I know is not a totally sexy topic, but it is one near and dear to my heart. And it had three very concrete recommendations in it, right? And we have just written a report that focuses exclusively on this, which I have sent to the Judiciary Committee, which I think is already posted on your website. But briefly, hopefully you can read it. It's a brief report, but briefly, the report said that Vermont needs to create and maintain a data systems for ongoing data analysis and planning, right? This is not something that Vermont was doing before Raise the Age. And unfortunately, it is not something Vermont is doing now, even with implementing Raise the Age, right? You cannot find relevant and useful caseload data. So often the data that's presented is important to looking at, let's say, DCF's staffing issues. Those are important, but it doesn't directly impact Raise the Age, right? There's this mingling of the charts of delinquency offenses or cases in young people and things like CHINS C, CHINS D, these kind of status offenses. That's relevant when you're supervisor at DCF and trying to figure out how you delegate your resources appropriately, right, across your agency. But for the legislature and for policymakers are thinking about, and for the courts and others are thinking about Raise the Age. What are those numbers? How many young people are we talking about? That data needs to be crystal clear. It needs to be delineated. What are the 18-year-olds who are now in delinquency that used to be in the adult system? Who are the 19-year-olds now who are going to be in family court, right? That needs to be there. The other second recommendation that was made was that the Vermont designate a particular agency or entity to collecting the data from all the different stakeholders, right? The data doesn't just come from DCF. The data also has to come from the court and others, right? From things like diversion and barge to get an idea of what these caseloads really are. DCF right now is I know through the legislature, is required to submit, at least last year, quarterly reports on a bunch of stuff, but including some on Raise the Age. But that data often is not including all the data from all the relevant agencies and is also not crystallizing, I think, for you and for everybody else, what is the Raise the Age data, right? That needs to be parceled out. Just very basic aggregate data, nothing personal, nothing, confidential. Just give us the numbers, right? And so that's an ongoing problem for Vermont. And then the other key piece of the report was designate an agency or group to monitor implementation, right? How's it going? You don't want to rely on, I mean, not that I'm not happy to help and share the data that we have gathered publicly to share with you how we think the implementation's going, but who's going to be responsible in Vermont? You've got a number of agencies and individuals and organizations, of course, interested in working hard on this. I'm not saying that there aren't a ton of them, but who owns it? Right? Who is ultimately responsible? It's awfully hard I think, for this committee and for the legislature if it's all these different parties with their different perspectives You do have two other agencies that obviously have done a huge amount, the Office of the Child and Youth Family Advocate's Office and Office of the Council for Equitable Youth Justice, right? Those, I know those entities are very important in monitoring. But the report in 2019 called for try to designate somebody to be ultimately the sort of the hub for this. I'm going to just say, though, that even if the data problems are plaguing everybody, it shouldn't hold up, right? These problems occurred before Raise the Age. They'll probably occur for a while yet. But you have a very important policy change, reforms on the table. And what we can say when we dig into the data that is publicly available is pretty successful, right? You had a smooth transition and implementation of Raise Age in 2020, which I have to say was in COVID, right? Those were tough times. Luckily, those are behind us, right? And you have a very solid foundation for implementation of Raise the Age phase 2 now. So you are I mean, I think it's happy news. I think it's good news that I'm sharing. You're in a very good position. Looking at other states that are doing this, Vermont is on very solid ground. I am just gonna see if I can. I just gonna wrap up my PowerPoint, and I'm happy to answer questions. I just want to say a couple of things, which is when you did Raise the Age as a strategic approach to public safety. Are you hearing music by any chance?
No.
Okay, I'm hearing music. I have no idea why I'm hearing music. Okay, just as long as you're not. A very strategic approach to public safety. You're talking about improving youth outcomes presently and in the future, right? You've got these are young people who are going to have children of their own. They're impacting their own families, their own communities. Hopefully, they're going to have good careers. They're going to be, great taxpayers. They're going to be leaders in our community, right? And I think it was a question earlier about, we invest now, but isn't this investment an investment for the future? Yes, it is. It's a smart, strategic investment for the future. So even if some additional resources need to be, used now, I would say you're going to save a lot in the future. The other thing I would say is that, yes, there are data problems. I see some major data problems in Vermont, but I have for many, many years. The thing that does concern me is that this year there was less publicly available data than last year. So I think we're going not in necessarily the right direction on that. But we don't want to hold up progress and reform. These are things that can be handled simultaneously, right? If Vermont is serious about this, they can address their data problems and they can implement phase 2 of Raise the Age. And then the last thing I would say is no action or delayed implementation is not exactly benign. You have 19-year-olds now who are being served. Are they being served in the most effective, developmentally appropriate way in Vermont? No, they're not. You have an agency, DCF, with expertise on adolescent development. They talked about how hard it is to get staffing and how important it is that they be fully steeped in the field and knowledge. Are 19-year-olds getting that now? It's not DOC's fault. It's not the adult system's fault. They are serving young people all the way up into their 80s, right? They're not focused on this particular distinct developmental age group. That is the advantage of Raise the Age. You are bringing young people to the side of the justice system, the judges, the staffing, the community group. This is what they do, live and breathe and do and are experts in. So I don't know if anyone has any questions. I'm happy to try to answer them.
Thank you. Committee, any questions or comments? Senator Rhodes.
I wonder if you could expand a little bit on the harm done to youth in the current system and in terms, yeah, I'll just leave it there.
Yeah, absolutely. And again, there's no intent to do the harm. But as we have studied sort of the benefits of a juvenile youth justice system, research shows that young people who, are equally situated, right? They have about the same age, the same level of offense, the same history of the criminal justice system. If one is for whatever reason put into the adult system and one is put in the juvenile system, the ones that are put in the adult system are more likely to reoffend, and the offense is more likely to be more serious. Right? You've put them in that group, and it kind of makes sense, right? I think I'm at college, a university, and we have a lot of college students. And, if you give young people opportunities to grow and develop and learn these adult skills, which is kind of what college is, right? It's 4 years to grow up in a pretty safe environment, right? And start to take leadership positions and those kinds of things, they really flourish. But if you have people 4 years incarcerated, right, in an adult system with no education, many of them are actually entitled to special ed and are not getting special education, that are not having, loving, consistent relationships, are not getting a chance for employment, right, and not figure out that, that's going to have a really negative impact on them. Nobody's fault, right? But you can't grow up in that environment and grow up and be healthy. That's it's sort of not possible. I mean, it's amazing some young people do as well as they do. It's just remarkably resilient, but it's sort of despite what happened to them, not because of what happened. The idea of raise the age is if you put them on the juvenile side, everybody is thinking about healthy youth development. What's the context of the young person? Where are they living? How are they going to be able to support themselves, right? How do they transition from being a young child, a youth, to being an adult? I give the example often of learning to drive. And I think it's because my youngest recently got her license. You can take a course and learn to drive. You can memorize every rule of a road and you can ace it. You are not a competent driver. And for the parent who's sitting next to them with the white knuckles as they get behind the wheel, and you're like, oh, there's a stop sign, right? They have to practice. And they have to practice hours and hours. They need to practice in the sunlight. They need to practice at night. They need to practice in the rain. They need to practice in the snow, right? They need to practice with other people around. They need to, right? You become a competent driver when you have these opportunities to practice becoming a competent driver. You become a healthy adult when you have opportunities to practice being an adult. And if you don't get any practice, if you're in a system where your opportunities are actually limited, an adult conviction drastically limits your future and your opportunities, it's going to have ongoing repercussions. And unfortunately, it's the justice system that often is the place of last resort for some of those folks. And then, you may get more victims and, there's a lot of costs in that. And then the other thing I would just say is that prison jail is a traumatic place, right? Whether you're harmed or you're witnessing things that are happening. We did a Justice Lab did reports on, obviously this is a very tough place, jail, Rikers Island. And they followed young people or all people for a year after release. And emerging adults just didn't do as well as anyone else. I mean, they did particularly poorly. And I think it's because it's such a vulnerable age and there was so much, they obviously had a history of trauma and the experience was further traumatizing. And again, that interferes with healthy development. I don't know if that answered it, but.
It did help to answer that, both the harm to the young person as well as the collateral harm to community and families. Did the Columbia research or the Justice Lab research look at all into the racial disparity aspect and the school to prison pipeline and how raise the age helps to combat that?
Yeah, we did. And we have in the 2019 report, there's some data from Vermont, again, not, right, data problems, they're there. Not as robust as we would, or any of us would like, but it did show racial disparities. Nationally, the most stark racial disparities of any age group is 18 and 19-year-olds. Right, they're overrepresented in the system. They have the worst recidivism rates of any age group and the highest racial disparities of any age group. So we're talking about a very vulnerable population, and disproportionately youth of color are being hurt, right, and feeling the negative consequences of it.
Thank you.
Any further questions? Thank you for your testimony.
Yeah, thanks. I'm glad to be here. Bye-bye.
Feel free to join.
Squeezes. It's like, oh, shit. Yeah, great. Morning, everybody. I think it's the first time I've been in here since January.
Yeah.
And I feel like I'm lost. Now I've been found. I'm just gonna, I mean, it's not a very long bill, but you want me to share the screen and put it on there?
Yeah, that would be sure.
I also sent a couple statutes a little while ago, just, it's the frame of reference for the bill, 13 VSA, 1454 and 55, which 55 is the statute that's being amended, before is the intent for the subchapter. And, as I logged on, for the record, Ben Dobrowski from the Office of Legislative Counsel. And before the committee this morning is H 118, entitled An Act Relating to Expanding the Scope of Motivated Crimes. I got it, yeah. So as the title indicates, the bill proposes to expand the scope of the state's hate crime statute to cover conduct directed at third parties and groups of people based on their actual or perceived membership in protected category. Mr. Chair, do you want me just to kind of, I can just go through the language, provide a little bit of context as to maybe how this could operate in practice? What's your prerogative?
both of those would be good. I do have some questions as to how it would be implemented in practice, but maybe we'll walk through the start would be good.
Sure. So from a drafting perspective, it doesn't do a whole lot, but from a substance perspective, it could. So you'll see, that section 1 of the bill amends 13 VSA 1455. And in subsection A, it strikes the victims, and how it would read is, so a person who commits, causes to be committed, or attempts to commit any crime and whose conduct is motivated in whole or in part by the victim's actual or perceived protected category shall be subject to the following penalties. That is being amended so that it would now read that whose conduct is motivated in whole or in part by another person's or group of persons' actual or perceived membership in a protected category shall be subject to the following. So the way the statute operates is really as an enhancement of sentencing. It's not necessarily a standalone charge, if you will. So the way it goes in practice is that if the maximum penalty for the underlying crime is 1 year or less, then this enhancement bumps up the penalty to that of not more than 2 years or a fine of not more than $2,000 or both. If the underlying crime carries a penalty of more than 1 year but less than 5, the enhancement bumps it up for not more than 5 years or a fine of not more than $10,000 or both. And then finally, under subdivision 3, if the maximum penalty for the underlying crime is 5 years or more, the penalty for the underlying crime shall apply, but the court shall consider the motivation of the defendant as a factor in sentencing. So it really becomes a factor at the sentencing hearing rather than sort of a strict limit on enhancement and how far it can go up. You'll see on page 2, subsection B is amended to reflect the same change as in subsection A, which essentially would say that a person's or group of persons' actual perceived membership in a protected category or categories need not be the predominant reason or the sole reason for this defendant's conduct. So essentially, it just needs to be a factor. And then finally, subsection C is unamended, but outlines what those protected categories are that would be covered by this statute. And that includes race, color, religion, national origin, sex, ancestry, age, service in the U.S. Armed Forces or National Guard, a disability as defined by statute, sexual orientation, gender identity, and perceived membership in any group. And then finally, the section 2 states that the bill would go into effect on July 1st of this year. So to give a little, I guess, context to this, like I said before, it really operates as a penalty enhancement rather than a standalone charge. So thus they can serve additional time of imprisonment or an additional monetary fine if they qualify. So like, for instance, what's a real world example of this? Let's take unlawful mischief, which oftentimes is covered by somebody spray painting something on the side of the building or something like that, right? So a person could be charged with unlawful mischief if they intentionally cause damage to property. So using my example, someone spray paints a racist or anti-Semitic symbol on someone's front door, and it caused less than $250 in damage, which is a monetary threshold within that underlying statute. The person can be charged with unlawful mischief. If they are charged, the prosecutor can use the hate motivated crime statute to enhance that underlying penalty of not more than 6 months in prison or a fine of not more than $500 or both, to a penalty of imprisonment of not more than 2 years or a fine of not more than $2,000 or both. So what that does is exactly that. It just takes that underlying penalty and enhances it, because if there was evidence to support that property damage was motivated at least in part by racial or religious animus. So that's sort of a way it could operate in practice. So.
Ben, I have a question, and I think so So in looking at the language, another person or a group of persons act or perceive membership. So, let's, for this unlawful mischief example with, let's say the only victim is the landlord who owns the property, but they're not a member of any of these groups. And how would he be the victim?
So under the current statute, he could not be the victim. And so so if this was someone's own home, it's a different calculus. But let's say they lived in an apartment. They're not the owner of the building. They're not the property owner. So the victim of that unlawful mischief crime is the owner of the building. So if their door was spray painted with some sort of racist symbol, they can't use the hate crimes enhancement to factor that in. What this bill would do, though, is that since the property owner is the one who's damaged by the property, at least under the current law, since the wording would expand it to another person or group of persons' actual perceived membership, and those persons lived in that apartment building, this theoretically would capture that action, that conduct.
But if those other persons in those categories didn't live in that building, the enhancement wouldn't apply.
Correct. Unless, because again, part of the factor is that, racial or religious animus, that would have to be there. So, if, there would have to be evidence to support that the person did that because, let's say people of color live in a certain apartment.
So another piece that I'm looking at here, the protected categories that we have.
Mhm.
It's the hypothetical. So if a group of people are protesting in front of a National Guard base, they don't make any contact with anybody who's in the base, but they're blocking a road.
Mhm.
So disorderly conduct. Local law enforcement built up, and these folks are protesting, a national policy regarding the military or something. They get arrested for disorderly conduct because they're blocking a road. They can then have their charge be enhanced by this.
I mean, as you know, it depends on the facts on the ground. But if there was evidence to show that their protest, I guess, didn't just have, wasn't engendered just by the fact that these people were in the military rather than military policy per se. I think that's a distinguishing factor that can be used as evidence. But if it was just the fact by sheer motivation that they are in the Army or the National Guard and really outside of that, then yes, it could be used as an enhancement in this situation. But it depends on the evidence.
I hear what you're saying. I mean, at least as I'm reading Section A, any crime and whose conduct is motivated in whole or in part. Then also looking at Section B, membership of the categories, not the predominant reason. I could see it going different ways. Okay. I'm just trying to think about different hypotheticals for this bill. Okay.
And the way that most of the evidence for this, since it's an enhancement and not a standalone charge itself, it would be a preponderance of the evidence standard. So at sentencing, if there was evidence about that motivation being driven by some sort of protecting category animus, then that would be the standard that would have to be proven either at the sentencing hearing or not, but there has to be a hearing on it. It can't just be submitted through the papers.
Any questions?
I understand a protected group is someone so forth. I guess I have a little problem with it. I'm sure you can explain it to me. That's another asking. When I think of membership, I think of membership into a gym or a golf or anything besides, I mean, is that the best term we can use is membership? I mean, is that to pay to get into this? I mean,
Well, no, I mean, and that's typically the terminology that's used in these statutes, but these are really, many of which are immutable characteristics that you're just born with. So, you know, like to your point, it's beyond just like membership in a gym. But that's typically how it's phrased in these statutes.
thank you.
And it doesn't have to be actual membership, it can be perceived membership as well.
Committee, any further questions from Beth? Well, thank you.
All right.
So, Todd, I'm sorry, we only have about 6 or 7 minutes, but we'll definitely have you back in the future.
And you let me know, Todd Delo's assistant from the general AG's office. Good to see you all again on the other side of Boston. We stand behind this bill. We see this bill as an important expansion of the existing protections for protected classes that are laid out in 1455. I sent a quick presentation yesterday that I think Kayla's got in the bill folder on this. Happy to walk through it at a future time, but it has pictorial representation of what the AG's office is trying to cover in this, largely from our civil rights unit. And those are images that include the defacement of public property with pretty straightforward, reprehensible symbols. I think the point that I want to hammer on, and I'm happy to come back at any point that is convenient for you all. The goal here is really just to capture those criminal activities that are hate motivated, but wherein the victim, the actual individual against whom the crime is perpetrated, is not a member of a protected class. That can be public property, and by and large, you'll see the images that are provided. Maybe it's a public road, maybe it's a public gazebo, or in the example that went back and forth between the chair and Ledge Council. You know, the door, this was an actual case that occurred in Hardwick where the door of a Jewish family was defaced with racist, ethnocentric, and hate symbols. But the owner of the property didn't identify as Jewish. And so there could be no hate crime enhancement because the technical victim of that property crime was not a member of a protected group. You know, to the example of a protest in front of a National Guard base, I think what we read in the statute is animus. And it's not animus towards a policy, it's animus towards a group as a group. I think the bottom line here too is, and what we're trying to do with this change is give prosecutors the tools to really stand up for Vermont's values around hate. And the real goal is to enable our state's attorneys and the AAGs to prosecute crimes. And it really is the state's attorneys, for the most part, who use this statute, the opportunity to stand up in those spaces where there's clear hate motivated crime, but where it doesn't fall into this in the statute. You know, we can talk about.
So a lot about the public property piece. I mean, well, just to preface, I'm all for prosecuting people who engage in hate crimes. I just want to put that out there. But, you know, from the procedural perspective, when we get to court, let's say somebody draws a swastika on a statue in the middle of a park. Who does the state's attorney bring in and say, this is the victim of this crime?
Well, I think there is a proof issue there, right? Under this statute, if it were enacted, I think it would require testimony that linked the individual's act, right? So swastika has multiple cultural significance. But if that swastika had been spray painted the day before a rally, during the high holidays of the fall, at other times that suggested a demonstration of animus, and there's an underlying crime, right? We always have to remember the crime itself is the issue. Hate crime is an enhancement upon that. We're not criminalizing expressive conduct. It's not constitutional to criminalize the expressive conduct. But frequently in the law, we look to intent, we look to mindset, and we look to speech, all of those as elements to look at the severity of the crime and to prove criminal intent. So going back to your example, I think a prosecutor would make a decision on whether or not to bring an enhancement based on proof that they've got available to them. And that proof might be Facebook posts demonstrating animus towards the group in question. There might be statements made that could be used against interest. There are other types of evidence that would come into play, but I don't think it would be enough to simply say it's a swastika. Therefore, I think they would have to have some language beyond that.
Yeah, I agree with that, but in terms of saying, this individual is the victim of the crime. I mean, who would they bring in to testify? Would it be people who saw it, or would it be the town, or?
I think it would be the racial animus in this example, if it were a swastika or another anti-Semitic symbol. I think it would be enough to demonstrate that the individual had anti-Semitic beliefs and that those anti-Semitic beliefs motivated this crime. Right, in the same way that you wouldn't necessarily have to bring in the victim of even a robbery if I can demonstrate individual broke into the house, took the money.
Yeah. Okay. Thank you. Senator Bohosky, do you have?
Yeah, but I need more time to maybe bring Todd back once I've had some time to process everything.
Yeah, please carry on if you have any additional thoughts.
Yeah, I think the presentation also showed what the purpose of this statute is. So 1455, as Ben demonstrated, is the actual operative language. 1454 states legislative intent, and the legislative intent very clearly was meant to protect individuals and groups who are protected classes of individuals. We feel that this addition, the shift from an individual victim to a member or group of individuals, really brings forward that original purpose and intent of the statute. Again, I'm happy to show the presentation if there's an opportunity to more time. I think the real issue, and I touched on it, and I assume that the Defender General will be in to talk about this as well. Their position, and I welcome the conversation, is that this statute, and certainly this amendment to the statute, runs afoul of the Constitution and the free speech rights of the Constitution. And I would say to that, sort of what I touched on a moment ago, which is, the Supreme Court has a decision that says, for example, cross-burning in and of itself is not illegal. It is expressive conduct. It may be reprehensible conduct, but it is expressive conduct. An outdoor fire may well be illegal under certain ordinances, and a hate crimes enhancement can add to the violation of that outdoor fire by demonstrating that the burning of a cross was intended as a hate-motivated act for a specific reason. That's what our statute does, and that's what this change would do, is focus, again, the conduct itself is not illegal because it is expressive. The conduct itself is illegal, agnostic of what the message is. It's vandalism, it's nuisance, it may be other already illegal conduct. Then the hate crimes enhancement comes on top of that to say, we as a society think this kind of conduct motivated in this way is and should be liable to higher increased penalties. Getting back to your question sort of about burdens of proof, I think that ultimately lies in the able hands of prosecutors to say, is this truly motivated conduct? Can I make the case? And is society, are the people better represented by increasing the enhanced penalty? And that's really all this would do, is give an additional tool to address that issue.
Thank you.
Absolutely. Happy to tap.
Yeah, definitely. Don't want to just give you 5 minutes, so we'll have you in the future, sort of get more time. Great, thank you.
Thank you.
We can go off.
I will read that.